Yes.
Only me. Yeah. If you talk hard. Alright, we're up there in the corner. Good evening, everyone. It is, my name is Anthony Tampone, Chair of Houston Board of Appeals, and welcome you all tonight. It is 6:06 p.m. June 12th, and I'm calling this meeting to session, in session. Start with the roll. So my left, let's go around.
Carl Hector. Harrison Demorada.
Casey Fassett, the zoning enforcement officer, is also here. Eugene Foley.
Ian Lozada.
Welcome, everyone. We're going to start off with approval of the minutes from our May meeting. Everyone's had a chance to look over. There was one amendment, right? That not Harrison that seconded to adjourn, right? I think that was the only one. Okay.
They did also spell your name is.
I didn't see that. I was going to be kidding.
Okay, who seconded to George?
Ian.
Yeah.
So with that minor correction, I'll entertain a motion to approve the minutes.
I'll motion to approve the May minutes.
All right.
Seconded.
All through.
Aye.
Let's see, we are going to take a moment to enter into an attorney-client session with the board here for just a few moments. So I'm going to ask members of the public to step out of the room for a couple of minutes, and we will come get you as soon as we are finished. Should only be a couple of minutes. Amy, can you stop the recording?
Yeah, you should make a motion to go into.
Oh, I want to take a motion to go into a attorney-client session.
I'll make a motion.
All right.
I'll second.
David?
Aye.
Hold on, one figure out. Can I stop it from here?
No, you gotta do it from yours, yeah, because you're hosting. Want to just try to keep it. Green, more needed, okay, perfect. All right, just let everybody else, move back in here. Yeah, give us one. You got the sign sheet, all right, all right, for a new business tonight, we have a public hearing for, applicant James Bacon Esquire on behalf of Wilbeck. Chapter of the Daughters of American Revolution for 106-122 Green Street. I will make a motion to call this public hearing. I don't know how to get a motion.
Make a motion.
Yeah,
Open public
someone want to make a public hearing on this
application.
application?
I motion to open the.
All right. And I'm going to second. Favor. All right. We are in public hearing for this appeal. Would you like to introduce yourself and state your case?
Thank you, Mr. Chairman. My name is Jim Bacon, first time before you guys. So just a quick little background about me. You'll see I've been doing land use since I guess the late 80s. I went to law school, went to Pace Litigation Clinic Land Use and started my practice in 92 and been working on all sorts of zoning matters since then. I was on the town board and planning board of Newport for 10 years. I've been the judge there for 18 years and but I've represented all sorts of towns and boards doing this type of work. So as you guys may know, the DAR, which Selena's here and Karen's here, their organization bought the Tappan House in 1907 for the purpose of saving it from destruction. I think this was the first time that an organization bought a house to save it for historical purposes in Kingston. So they have an honorary plaque on there that says, you know, it's an honorary listing for on the historic preservation list. So when they bought it, they hired a famous architect, a guy named Myron Teller, and he oversaw the restoration, and which included our records show that they did all of the windows and everything and redid it. And so they've been keeping it as a museum since since they finished the renovations, I guess in the 20s and like 100 years ago. So now what happened is about 4 or 5 years ago, they noticed one of the windows, storm windows, was laying on the sidewalk, and they said, we have to do something about these windows. They've been in there for more than 100 years. They need to be fixed or replaced. So they hired their experts and they decided that they were going to have to replace these windows with exact replicas. So they hired their guys. They looked over to whether it was going to be Marvin or Anderson, and they went with Marvin. They did Marvin custom windows. They came and they measured down to the millimeter every single window, 32 windows. And they bought the windows because they had a meeting and they said, we have to look at the code of the city and see whether or not this is allowed. So at that time, the city had guidelines, which basically said, if you're not disturbing the exterior of the house or you're replacing it with something that's exactly the same, whether you're painting it or whatever it is, you don't even need to come to us for anything. You just go ahead and do it. So they said, well, this sounds good to us. And they bought $65,000 worth of windows, which are still in my basement. And they were ready to put them in. Now, unfortunately, one of the ex-board members called the city and said that they were going to put in vinyl windows. And they're very against it. So, of course, the city said, okay, come on in, tell us what you're going to do, and we'll review it. So they didn't have an attorney at that time. They went in. And as boards sometimes do, they looked at it and felt that the board had the power to say, you have to repair all of your windows. You don't get to replace any of them. So they took a denial. And then they came to me at sort of the 11th hour, and we brought an Article 78 before Judge Graff, and we had a meeting with Judge Graff, and basically Judge Graff's like, well, what's the problem? But I couldn't win the case because we had brought it after the 30-day statute of limitations. Very short statute of limitations for the general city law. And that's the corporation counsel had put that in a footnote, but that was what turned out to win the case for them. But again, when, and I'm not saying anything that's not in the public record or I haven't discussed with Matt. When we sat down with Judge Graff, she said, look, this seems ridiculous. This is an organization that wants to preserve this property. This is a city that wants to preserve the landmark district. Why is there a fight about this? And I can't see how replacing these things with exact replicas is going to impact the landmark district. So we went back to the commission again with those same arguments. Said, look, commission, please look at this. Here's the court's decision. We think there's reasonable grounds to replace these windows as they are. There's no impact on the landmark district. But no, we could not get through to them and they denied it. We went back to them for a hardship. Said, look, they have $60,000 worth of windows, $65,000 in their basement. They followed your guidelines. There's the hardship. Please let us go ahead. No, okay, we'll not let you go ahead. So we come to the ZBA. Now, the good thing is, as Matt must have told you, the ZBA is charged by the code to look at the same criteria that the commission did in the first instance. So you don't have to, it's not like a use variance, very, very difficult to get, even an area variance. What it is the criteria is that, does this project have an impact on the character of the landmark district? And if it does, then you can deny it. If you find that it doesn't, then you can approve it. So that's why we are here. We really don't see, and I asked the board, I said, look, if you guys are going to deny it, I want to tell you guys tell me on the record how replacing these things with exact replicas is going to impact the landmark district. Well, of course, they couldn't do that because it's impossible to say that. So again, I think they were hung up on saying that, well, we have the power to force you to repair these windows. And they really were hung up on that, unfortunately, and we couldn't get by that. So we are pleading with this board to allow the DAR to go ahead and replace these things.
Thank you.
So it's been a number of years. If I sound a little frustrated, I apologize, but you can imagine.
Frustrated as it is.
Yeah.
4 years. 4
But
years.
we appreciate you guys taking the time to look at this.
So I'll make some clarification.
I'll apologize. So a couple things just with regard to the application. So I know I had discussions with the chair earlier today and trying to do research pertaining to, again, which standards are going to be applying before them. And one of the things that was discussed is there's the other section, subsection 15 on appeals. And discussing further, so the criteria that is potentially before them, trying to clarify whether it's the original criteria or again the hardship criteria. And it seems there is a bit of where there's the one subsection that we're talking about, that we're originally talking about, which has the reference to 26L14. And then there's this other subsection, which is the section 15, which Anthony had brought to my attention. And we looked at the previous subsection, 14, which seems to be an appeal, but it does also state, and I can kind of show you. So this was former 14 disagreement president. Yeah, okay. So it does apply to your criteria
It's a typo that.
That's what I
Typo
mean.
renumbering.
It was a
they were
typo,
formatted
but
back.
so I guess the question then is this criteria. Is applying to your initial criteria. This is the former one. Right? And then it was changed, but this is supposed to be referring to your criteria that you're talking
I
about,
think that's right.
but now, okay.
Yeah.
So just
I
to
saw that too.
clarify-
It didn't make sense to me.
So there's a contradiction in the law is what,
But luckily,
Proceed.
when it says appeals, there's no, it doesn't specify what standard to apply for the appeal. And the second one at least does say that it goes back to the section of the original criteria that the commission had found.
so I guess just to clarify, because there's the two sections, this one, which was referring to that old section that is referring to the original criteria, and then there's also this other current 15, which he's talking about the hardship criteria.
So we might have, we had before us an application submitted by, Mr. Baker.
So what you're requesting is that
Specific to the hardship.
But what I'm saying is he's referring to the 14, which we then
Yeah,
discovered. So 15 actually has the hardship criteria.
Hmm.
What this section, which is what your initial appeal is on, has the other criteria.
Okay, so you're saying that the
So
code could be read that both of them apply?
it sounds like there's potentially, well, that's why we want to clarify, I guess, for the record, that you're saying that your argument is that it's based on this section, which was a reference to the former appeals section and
Yeah.
not the current
My
appeals
reading of the
section.
code
Yeah,
was that the board, that the city replaced this code as best they could, last October or whatever.
No.
And so that that was basically a typo that was left over. I think the intent was to allow the ZBA to look at the criteria with fresh eyes and look at the record and see, and be an appellate jurisdiction. I mean, why would you have to do a second hardship, right, Matt? I mean, the ZBA had
and
it.
I just want to make sure that the record is clear that, yeah, so that's basically the argument for which criteria to apply
Yeah,
is that the initial criteria based on
that's
in the event that this
yeah.
applicant may appeal for review of the application applying landmark ordinance criteria.
That's my interpretation. Otherwise, they would have said hardship instead of an appeal. Well, for you guys, they'd say, okay, you did get the hardship from the commission, now go for a hardship from the CBA. But they didn't say that. They said an appeal, and then that section that talks about the original criteria. So I think you're on solid ground. That's my reading of it.
Okay, so just to interpret, and that's different from the separate appeal section, which is 15, which regards, it says, with the hardship decision, file a written appeal for review of the decision. So where the statute that you quoted, the 12B2, it's your applicant's position that is referring to the specific criteria that you would not the hardship criteria.
Right.
Did you have a different application than the only application I have is an April 29th letter written to the board regarding the hardship application.
I think I did a subsequent appeal just to the ZBA. There was a hardship application.
Am I looking at the wrong one? Maybe we're, okay. Okay. Sorry, maybe I'm looking at the wrong. Okay, yeah, okay, sorry, yeah, this one. They both start with hardship application, yeah. So I guess I'm unclear on whether or not the appeal is specifically for the hardship, because that's how it's phrased. And then there is other language, including other factors. So I just want to be very clear on what it is that is actually being appealed, this application.
All right, well, I'm pretty sure that I tracked the new code as it was. Because I actually talked to, communicated with, Ethan about this to make sure I had the most recent version and actually corrected him because there was, some of the old code was still on the website, so that's no longer the case. The right PDF is on there, so.
But do you want to allow, so I think that we can clarify just so that the record is clear for this, but do you have any specific questions that you want regarding the criterion application that they're presenting before you? Or I would say, if you want, after you're done and there's, if you ask and see if there's anyone else who wants to speak,
Yeah.
and then we can either close the public hearing and go into a subsequent attorney-client session if you have any legal questions.
Yeah, so I guess, Mr. Chairman, if there's any ambiguity in that at all, it's we are meaning to appeal the hardship, the denial of the hardship. And my reading of the code says that in looking at that appeal, the ZBA is to apply the criteria in the original instance that the commission was supposed to examine in the original instance of going to the ZBA for approval. I've been going to the commission for approval of the for replacement windows.
Can I say something?
Yeah, here, you just there.
Yeah, if you would like to say something, you just sign in, and then.
And you are part of the applicant.
So this is Selena Gomez. And she is
National Society of Daughters of American Revolution. In my understanding, in recollection of the hardship portion of this, we went through the original application, got denied. The next step was to go for the hardship. The hardship criteria listed in the code really don't apply because do not intend on selling this property.
So
it really doesn't apply in our situation. It all refers to about whether you get market value or resell it or whatever. And that really doesn't have any.
yeah, it was more of the economic impact. But
Yeah.
yeah, so I think, I know it's a little confusing, but I think that was a typo. I think they meant to say, 15 instead of 14. And it's sort of clear from reading the whole thing that,
Oh, it's definitely supposed to say.
If it's a question that I'm saying that I think kind of clarifies his argument, the applicant's argument, is that 14, as it was written, is referring to actions by the committee in approving or limiting. And at that point, it's called a preservation notice of action. It's not a certificate of appropriateness, but it's basically the same thing. It was supposed to be equivalent by applying the landmark ordinance criteria.
yeah.
Yeah, but our code as it written right now is only typically says the hardship.
But there's two separate sections. Where this is saying applying subsection that he's quoting 40526 L12 applying land or more ordinance criteria. And then as he discovered, it was referenced in the old section of the code as the old section was written. I think he actually, contrary to the hardship application proceeding, I think there's actually a good argument for that. Again, I think this is something if you want to discuss further after it's done, we can go through, but
Yeah.
that also contradicts 15, which is separate. But, and that's where I was trying to distinguish with him that subsection B4 is appealing and saying that it's not appealing on the grounds of 15, which seems to just apply to the argument.
Yeah.
And also that, the other reason why it should be read that way is because after, as the board probably knows that this, if there's any ambiguity in any zoning code, so the tie goes to the runner, goes to the property owner. These,
Yep.
all of these laws are meant to regulate property and have a proper development, but it's not meant to take away the property rights of the applicant. You know, they're still, it's meant
Sure.
to go ahead, and so any ambiguity sort of goes to the applicant, but
But
I-
this isn't an ambiguity in the code, this is this is you know, this is a typo in the numbering of the administrative part of it.
I think
mean,
that's- yeah.
I mean, yeah, we'd
I
have
think
to
they're
have separate, I mean, we might have to have a separate conversation about that.
no, I saw it too, I was like, this has to be a typo.
So, all right, well, I guess, you know, maybe we can start with the hardship and then, because there are a few things, I have a number of questions here and, you know, let me, does anybody, is everyone on the board kind of clear of what part we're looking at or have any more clarity on what type of information we're really looking at here in order to try to make this decision, like what metric we're.
Yeah, I'd like clarification on what the hardship, are you saying the hardship is the $60,000 spent on the windows, or is the hardship the deterioration of the windows?
Well, I think the hardship question was before the commission, and I think that was specifically in place to review the original application. I think this board's jurisdiction is not looking at the hardship, but I think it's looking at the original criteria to see if the board made a correct decision in the first instance. So it's strangely written, I know, but I think from a statutory construction standpoint, that the code gave the commission the sole power over a hardship determination. For whatever reason, I know that from a ZBA perspective, you guys are always looking at hardship with use variances. But the way that code is written, the hardship is particular to the commission. Once the appeal goes to the ZBA, then that section says that the criteria to be applied is the criteria in the original instance that the commission would have looked at in deciding whether or not this application is consistent with the landmark district. So I don't think this board has to, we're happy to answer questions about the hardship application and why we made the arguments we did before the commission so that you guys understand where those arguments came from. But I think in terms of applying the criteria is the consistency with the landmark district. So
I guess-
like I said, we're happy to get into whatever you want to
Yeah, well,
talk.
thank you. I guess just in my mind, the criteria number one is hardship shall not be self-inflicted. So what is the hardship in this case? And then why did the HLPC find it to be self-inflicted?
Okay, that's a good
Because
question.
that's,
So
I mean,
if we get into the hardship questions,
it's a great
so,
run through criteria. I mean, that's number one. I
Yeah.
need to know what the hardship is.
Yeah.
And I think it's good context to know why this other body determined it to be self-inflicted.
so the hardship was not the windows are deteriorating. That's
So like,
That's, we didn't make them deteriorate quicker by, you know, they deteriorated.
so I guess the kind of following in, which is my same thought process here, I think, is, we're determining like what the hardship is and what the process of this would have typically been, right? So, you know, had there been an application, this went in front of the HLTC, my understanding is that like there was a movement based on what I've read here, that the windows were purchased before HLTC heard this, right? So that the normal process would be that it would be heard. They would say that we favor, you know, the repair of the windows. You would have a quote for repair, right? I haven't seen anything yet that have actually like had said whether or not. I'd love for you to answer the question, but I want to frame everything first, right? I haven't seen anything in the application to the HLPC of like someone that actually, just a couple of notes of someone saying that they couldn't fix the windows and, you know, we know that that's not impossible. It might be wildly expensive. I don't know, but I don't see any quote on whether or not actually having the windows be repaired. You know, for the actual repairs.
I would say one, the hearing get needed.
Yeah.
And definitely you can like ask certain questions. And I think when you guys start discussing and you go to the arguments, do that after the.
Okay, yes. So yeah, I mean, I guess.
Sorry to cut you off. Exhibit B is they had a contractor come in and he said that like they're basically like the condition they're in, so he didn't give them a quote for repair because he's like, it's not, can't just do it, it's not worth it, yeah.
Is that true?
Yes, he did come in,
Oh, did he
he gave us a quote,
Okay.
and it was basically the same price as what the new windows would be.
Mhm.
And he said he would not guarantee them because he didn't feel that what he could do them was called the Dutchman's repair,
Mhm.
that would not hold because the windows were so bad. And,
Did you get multiple quotes?
oh yeah, we got 4 or 5 quotes.
And they all said the same thing.
No, we got quotes on different things and then once we realized, we talked to a couple different people and then we realized, okay, so what are we gonna do? We went back and looked at the guidelines a second time to make sure that we were no problem. And the guidelines stated specifically, if you are repairing or replacing with exactly the same kind, then you do not need to go before the board. So that's why we didn't do that. Then we said, okay, what are we gonna do? We checked with Anderson, Genwin, a whole bunch of different window companies. And because Marvin did the most historically correct windows and had done them across the country, on just about every state, you know, courthouses, old houses, museums, you name it, they've done. And they looked and they came to our house. They gave us an estimate. They measured the windows 3 different times before they did anything. It took us 6 months to get the windows because most of the windows are made by hand. And the windows are single windows, 2 divided windows. So the whatever we're gonna call, I can't remember.
Basement,
Right, are all, you know,
or not basement, double hung.
yes. So we figured, okay, how much is this gonna be? They told us it was 65 and change. So that's why we decided, okay, that's who we're gonna go with, and that's why we went with them.
They're wood windows and we're replacing wooden windows.
Right, wood windows for wood windows, and they look exactly the same.
Double, existing ones are double hung, the new ones are double hung.
There's,
The divided lights all match.
yes, everything right down to like a millimeter. They're exactly the same window. And we even went back and looked to see, okay, what kind of paint did we need to get? We got the correct color paint, which is,
Benjamin Moore, 01, what?
yeah, because that was a flat paint, which is what would have been historically correct at that time. I mean, we've done everything that they asked us to do. And 4 years later, we're still, I mean, granted, yes, it would be nice to be able to, you know, put the windows in, so at least we could show something for what we paid for them, but our main thing about putting the windows in is because we want to keep this house going. We're the caretakers of this place and we want to leave it in better shape when we're gone for the next.
And to make it look better than it is today.
Because it's falling apart, the windows constantly, we're getting I'm the house manager and I'm getting phone calls all the time. This window, the pane fell out on the sidewalk. You know, somebody called because a couple of the shutters fell off and almost hit a car. You know, I mean, so we took down the shutters to make sure that that wouldn't happen again. We've cleaned up all the windows that we had to do. And, you know, I can honestly say with all, as far as I can tell, in the past 20 years, the only windows that have not been changed, the glass in the windows, is 2 windows. And they're both in the bathroom, which were put in 1907. Those are the only 2 windows that don't have a change in glass. And I know that because being house manager, I had to pay, because I'm also the treasurer, I had to pay the bill to get all the, you know, the guy to come in, take the old window glass out because it was broken or it fell out on the floor. I mean, we've had whole windows fall out on the floor, you know, glass, wood, you name it, and had to have it repaired. You know, we need to have these windows fixed. It's costing us an arm and a leg just in gas for heating it, you know. They're not energy efficient. And
So, Mr. Chairman, I just want to say, so I know we're still in the public hearing, but I know you're going to get to potentially discussing the hardship and why we went that, I mean, we had to go that direction because that's what the code says. But the hardship, as we saw it, was we relied legitimately on the guidelines of the city.
exactly.
And then,
Talking about, I want to clarify so
Right.
everybody understands, there was a,
I got them in the record. I got that in the record.
of Kingston Historic Preservation Guidelines. It was about a 20-page document. And it said, if you're replacing wood with wood, or you're painting in the same color that's existing, you do not have to go before the landmark commission. And that's what we were doing. We were putting wood with wood and same color. So that's why we purchased the windows before even hearing about anything from the city.
Question for Casey, if that's all.
Mhm.
If I were to replace the windows in my house, would I have to get a building permit prior to doing that? Was that, did you apply for a building permit prior to ordering the windows?
No, that was our next step. The gentleman who was supposed to put in the windows would have taken care of that. And, you know, and that would have been, the contract would have been in his fee that we would end up having to pay him. It would have been
And
done.
it's,
Yeah.
we've learned, after the windows were ordered in our possession is when all the stuff with the HLPC and everything. And it's my understanding that we have to have that approval before we would be granted a building permit to begin with.
Right.
So that's where we are today.
Is that the case, or do you apply for a building permit and then the flow chart, do you?
Typically, the contractor would apply to the building permit because we need their credibility of all that.
Right.
It's usually the first step.
But it's after the landmark commission says they're okay with it, right?
No, you apply for the permit first.
And that triggers it,
And
right?
we
That's what
haven't,
triggers everything. The
We
first,
had-
the first thing you do is apply for the permit.
we haven't even gotten the windows yet. Like I said, it
You
took
would-
6 months.
You wouldn't order the windows until the permit.
Well, see, we didn't know that.
That's a conversation between your contractor. You know, so,
I'll be calling him later.
yeah.
I mean, that's a lot of windows custom built, so they probably said they needed the lead time anyway, so.
Yeah.
You know, permits, how long can a permit be open before it was issued? 1 year? Yeah, so if it took them longer than that to stage the windows and everything, the permit could have expired.
Everything will be renewed if there's a problem like that.
Put the cart before,
And
cart
really,
before the horse.
there was no reason for them to doubt the guidelines. They were on the website, they had the pamphlet, they were very clear.
Right.
Are they still on the website?
With that,
Are they still on the website today?
no, they're not anymore. I think this case
That's
made
a result.
them take it off. They're not on the website anymore. I don't think they're officially the guidelines of the city anymore. I mean, it seems reasonable to me when you read those, but I don't, Matt can clarify more. I think
When you were talking, when you first came into your, whatever to us.
Okay.
You mentioned vinyl. They're not vinyl, right?
No,
Okay.
So that was, that person misspoke. That's what it is. So, see no longer on the board. Good job hanging in as long as you did.
Are we still getting clarification on hardship? Right? Or?
I don't know if we got it necessarily.
So there definitely, and based on looking again at what you're saying, there's two separate, ways of reading. There's the two different parts of the statute. And I think to make a complete record, we really need to address it separately and then discuss which, based on a reading, you're going to be applying.
You think that they can fit on one or the other?
Well, the thing is, I'm just reading it. This subsection, 12B4, you're applying landmark ordinance criteria, and it says as defined, and it's quoting the old section, which the old section was that appeal section that talks about, disapproving or limiting a preservation notice of action, which is the certificate of appropriateness today. Application criteria. So that is still in there where they're saying you're applying, even though they have the wrong statute there, you're saying you're applying landmark ordinance criteria there. I know subsection 15 contradicts that because that's directly is saying hardship facilities. So there's multiple ways you could read this, that they are appealing based on 12 stated, not on 15. The appeal pursuant to 12B4, which applies landmark ordinance criteria. Not necessarily 15, which is applying the hardship criteria. So, or, you guys can, it's up to you how you interpret, but I definitely have a good understanding now, seeing specifically what the applicant is saying with
So 40526L14, the original one, is still there, just under a different title or heading. Is that what you're saying?
now 26L14 is no longer there, but that was the part that's discussed as the landmark ordinance criteria, which is, I guess, the criteria itself is under a different.
Oh,
Okay, that 14 was referencing the landmark criteria under that head. So.
Yep.
I have the original print here. The original L14 just says appeals. Any aggravated party or by an action of the commission in disapproving or limiting preservation notice of action application may bring an appeal to the zoning board of appeals.
And what is the criteria for the preservation notice of action? It's the same criteria that they switched the name over for the certificate of appropriateness.
What section would be what?
That would be the subsection that he refers to, I think, is
So we looking at the landmarks and review
L10B, that
and
preservation. No. Where's the preservation notice? That is what the preservation notice of action, and then look at what it is for the certificate of appropriateness. certificate of appropriateness is the term that's used in almost every other jurisdiction. That's why they changed it. We, in unique, where we were using those of action. But a certificate of appropriateness is what most jurisdictions use in most, the state criteria from SHPO refers to it as certificates of appropriateness. So that's why they had made that change in our law.
Outside of their questions, the new windows, are they single pane glass or
Double.
they're double pane panes?
Provide like,
Insulated, like,
yes.
For energy efficiency.
The issue is there's ambiguity within our code. There's two sets. So there's what he's appealing under, so I guess you can interpret it as either they're referring to two separate types of appeals or two separate criteria. It's gonna be up to you guys.
Well, I guess that's kind of my biggest challenge wrapping my head around which exactly what.
I guess from my perspective-
Specifically, what is being appealed to.
So, again, Mr. Chairman, I think from a statutory construction, I looked at a lot of statutes. So the way that this statute was done was that the commission has the certificate of appropriateness, that's what it's called now. And then if that gets denied, you go to them for the hardship. They're the ones with the, in my opinion, the sole jurisdiction over the hardship issue. And then if they deny that, then you go to you guys. And and under that section, it points back to the original criteria. So you guys look at that and see whether or not, in your estimation,
You guys
I'm
have
sure
the power
how
to
it
interpret the code. That's basically power. And if I can, as simple as possible, kind of break down is that our code specifically in that section in which this appeal is applying landmark ordinance criteria.
Which is that 10-day?
That would be the appropriate way because that is what was originally referenced as they're referencing here, the outdate, they didn't update that. So that would be the logical.
Yeah, that's another thing in the code because there's no title of landmark preservation criteria.
Yeah, it doesn't make your job. It didn't make our job.
Can I just say, if you looked at our house and you had the new windows in, you wouldn't be able to tell that they were the new windows. That's how much they look exactly like the old windows, except for they have new paint on them and they have, like they've been fixed.
I think everyone, I don't think anyone here is going to argue whether or not the building should be like maintained and look good and work right. Part of it is why the HLPC made their was adamant about the restoration of the windows versus replacement. I'm sure to a lot of people it might not look very different. And they obviously have an argument. They favored that.
I'll tell you exactly why. Matt can disagree with me if I'm wrong, but so what they did was they looked at the criteria for nationally historic buildings on the register, and under the federal guidelines, it allows you more power to look in the interior and look at the interior of the windows. And they believe that they had the power to do that. What we said was that this structure is not on the federal or state listing. it's locally listed and it's listed as part of the landmark district, but they don't have that extra jurisdiction to require the repair of the windows. They don't, because the repair of the windows, whether or not it's replaced or repaired, it's the same impact or no impact on the landmark district as a whole. So the landmark district, the way it's written, is that is this change going to affect the character of the surrounding buildings, the character of the district? And so that is why the court, in its decision, said it's difficult for the court to look at this and say that there's going to be any impact to the landmark district. So it was a misunderstanding by the HPLC of its power, which in my estimation, they were overreaching and trying to force them to do something that they didn't have the power to do. And I think I would win in court on that, and I think that's where it was going. But Mr. Chairman, that was the big hang up for the HPLC. They believed they had that power.
But so still first we're deciding, right, which thing we're making a decision about.
Well, you
I
need
think
to,
we do the, yeah, in closed session.
yeah, let them present completely,
Yeah, so it's, I guess we're almost at the end of the public hearing part of it, but yeah, so it's our position that the code as we read it has you guys applying the landmark criteria. And although it's could be much clearer, that's the way.
there's clearly an error in the code.
Yeah.
That was not updated.
Yeah.
So you have to look at the statutory construction. We'll discuss further what the intention was and what, this was originally referring to. You can look at that to try to derive what the intention was. And they clearly left that in that say your landmark criteria, landmark ordinance criteria.
So again, the type, basic statutory construction, if there's ambiguity, the tie goes to the runner, the tie goes to the applicant, that we have the benefit to allow you guys to interpret it in a way that benefits us. That's sort of like the bedrock statutory, whether it's zoning or planning, whatever it is, if you can read a code in a way where it's going to benefit the property owner from a constitutional standpoint, property ownership and the Fifth Amendment, all that, that's the way it's read.
And like, just so I understand, the whole hardship application was basically procedural. You needed to go through the hardship
Yes.
appeal to then be able to.
We had to, and even though, as my client said, some of those didn't apply at all. It says, how economically, can you sell it to somebody else instead of what you're trying to.
Intent of
We're
what.
not even gonna do that
Yeah,
exercise.
so
Can't.
But that's intent versus
It's in.
that was,
possibility.
It
So
is-
that's not a,
It's never.
yeah, and we tried to explain to the commission that
It's in there.
the hardship,
That you cannot.
it doesn't apply, but, again, they were pretty steadfast.
And so when the HLPC ruled, they claimed that the existing windows must be restored to maintain the structure's historical integrity. That was part of the.
Yeah, and we're saying, look, you guys don't have any power over structural integrity of our building. That's our business. Now, whether or not that impacts the landmark district, that's your business. You guys have the power over deciding whether or not something that goes on the exterior of the Tappan House, it's going to, if we're going to paint it pink or blue or some weird polka dots, then yeah. But now the structural integrity of the building, that's our building.
Oh, it said structural historical integrity, I think.
Yeah.
Structures and historical integrity, that's my
We
fault.
gotta also
But,
keep in mind that this building was slated for demolition, right? Prior to us purchasing it, so it was in very bad disrepair. The whole interior was gutted and all the repartitioned and everything else. We've been looking for information, can't verify that there were or were not those windows replaced. we assume there were, there's old postcards that look like there's red paper shreds hanging from the windows where perhaps some tenant had put paper where the glass used to be. And
So
even so, the windows, when we had the renovation done, were from 1907, 1908 timeframe, and they're not gonna last forever, right? Wood doesn't last forever.
So when you did that research, you found conclusive evidence that they were replaced during the 1907? No, you didn't. Okay.
No, but what we.
But the background of your organization is one that deals a lot with historical preservation, so
Big thing.
Exactly.
you have reason to
And
believe.
I mean, the structure is stone, so that's not gonna go anywhere. And even if it was replaced in 1907, it's still not of
Right.
the
Well, it said that,
17th century.
it was repointed, the stone was firmed up, but yeah, I mean, you have to go back to 1907 to see exactly what the conditions of the windows, but we all know. And that, they didn't have like polyurethane or anything for those windows that were put in whatever, 1700. So by 1900, they had to be falling apart.
Yeah, it's a reasonable and for.
Well, not only that, but the front door, the front porch, and the two side windows on the front were put in by pellets. They were never there. None of that was there. Two windows upstairs, they cut them into the stone. So the house is not the way it was. Even after the British burned it, the house isn't the way it was. It's twice that size.
And you can even see like in the basement in the southern window wells where there were bricks on either side put in on the inside of the stone opening so that it was narrower than it was originally. So, and we don't really,
But I want to work on that.
and the annex the same way. So I don't think,
Yes, this is what made the judge kind of shake her head, was that this is an organization that's dedicated to historic preservation.
Well, so I mean, this organization has owned this property since 1907. Right?
Yes.
And so assuming those windows were in good operational, state in 1907 and its continuous ownership, why were they allowed to become in such a state of disrepair?
Well, when we got the house, and it's not like the DAR doesn't own our house, our chapter owns our house. When we got the house, it was ready for demolition. Half the windows were missing glass or pieces of wood. We've got pictures.
From
same after the
1907.
renovation.
Right, oh, after the renovation.
1907. So
Right, after
you've
the-
had it since 1907, and the
Right.
windows that are in there have been in there since.
They have to be painted and whatnot.
Yes.
For years.
I mean, we tried to maintain them and had them reglazed, had new glass.
And we
put
haven't
in.
touched a thing since all this.
Yeah. We've had, most of the women before us were, and I've been there almost 25 years. Most of the women thought of the house or the money, let's say, that went into the house was their money and didn't want to spend it. So it's come down to us where we have to do something, and we have spent probably over $100,000 trying to repair what has not been repaired in the past 50 years. Because the house just is, it's in disrepair and it needs help. And that's what we've been trying to do, whether inside, outside, whatever, we've done what we can with what money we have. And we don't get money from anybody. It's left to us in wills, or we have to do some kind of fundraising in order to make money. We don't get a check from, the government, or we don't get anything like that. We don't get grants. We don't get any of that kind of stuff. It's just what we can do that we have to
And
do.
we only have 50 members, and I'd say at least
40 of them don't
40 of them
show
are
up.
on social security and everything else.
Yeah. I mean, we're trying to maintain the house so that it's there for the next 100 years. That's our goal.
Within our means.
Yeah. And we thought we were doing the right thing. We didn't, we wouldn't have done it the way we did it if we hadn't thought we were doing it the right way. That's why we looked all this stuff
I'm
up.
sure you didn't get yourselves here on purpose.
It's been, I've spent over 1,500 hours on this window project alone, myself. 1,500 hours. I mean, that's ridiculous, you know. But that's how, that is, what I don't think any of you understand, because I don't know if you've ever been in our house, but she's beautiful.
I've never been inside, but I park right across the street.
I love this house, and everybody who contributes to the house loves this house. And we want it to look the best it can possibly look.
You'll have to come over when you're.
Yeah.
Older.
So the email from Susan Cahill states that the structure is on the state register.
It is only on any register because it's within the
Okay,
stockade
just,
district.
that's it.
Okay.
We are not personally,
The
listed.
property is not listed.
it's under a blanket coverage, as that's what the state told us. It's a blanket
Yeah.
coverage
If
because.
you go
we
on
are in the
Wikipedia
stockade district.
and you look for the list, this is not,
No,
it's,
we're not.
it's just, it's because, like they said, it's in the landmark district, so it has, you know, you guys do have jurisdiction. because-
And basically,
Yeah.
But
I just wanted to double check.
if it was individually listed, like, I don't know, the Vanderbilt Mansion or, you know, something like that, then that's a higher,
Well, that's on the that's the
That's right.
national above.
that's higher, you know, higher amount of jurisdiction that goes into that. Yeah, you know, that includes interior work as well.
Yeah,
So this one doesn't.
yeah, see, that's why we
the
can't get grants.
HOPC has I think it's still the same in the current code. When we started this mess, anything seen from the street is within their purview.
Yeah.
And
So part of it,
else-
for me, from a legal perspective, I'm saying, well, you don't have the power to come in and say, okay, this is you're inside the house. You have to change this. No, that's the interior. You can change the outside. You don't have the right to say anything about the interior of the window. That's in the house. But, you know, that's a legal thing, but anyway.
So if that's your stance, why was that not the action taken against the city on a, whether or not they had jurisdiction to make a
We
ruling?
did, but, you know, like I said, the statute of limitations were only 30 days, the general city law. That footnote was very valuable for the city.
We had an attorney who retired and went off the grid before we found out and then found.
It was months later that we found out that he just closed his office and skipped. So that was like, and he had sent me a letter stating that we had,
90 days.
90 days, and that was it. And we were down to the last like 20
Right.
days.
No,
And
we-
that's how we found it.
We don't want any more litigation with the city, and I think it would be detrimental to the city basically the whole job of the city for a judge to say what exactly you have jurisdiction. I mean, it's good for you guys to have discretion and to be able to try to implement the purposes of the code. I don't think litigation is going to be good for anybody, so, but we would like to avoid that, and I think we've done a lot of work
I
on
think
this.
everyone agrees.
So, said the exhibit C, the preservation guidelines were taken offline,
Yeah.
and was anything put in their place?
I believe so.
They revised the whole code,
Yeah.
Okay.
they took out a
So this
lot
is
of,
part of the,
in
That's
fact,
a standalone document, originally.
yeah. In fact, what I relied on in the lawsuit, there was 2 different sections that were still on the books. And so the judge said, well, look, you first. You know, they didn't really get into it because of the statute of limitations issue, but you know, the city certainly tried to clean things up, and I think they did a pretty good job with it.
Not good enough.
For that typo.
Yeah.
But yeah, so I know you guys probably want to deliberate, if there's any more questions, you know, otherwise we can close the public hearing, we'll go out, we'll come back in, we'll talk it, as long as you guys want
You
to.
can stay, it's a public meeting, you don't need to leave
Okay.
unless we're going to attorney session. I didn't see it in the HLPC's documents, but you said that there were quotes for repairing the windows as they asked for.
Yeah, we
Could you provide that,
It's on the HLPC information, if you go back on the website under the meetings and agendas.
No, but we had three,
Yeah, but I didn't actually see the documentation.
we
The
had,
documents are all in there.
we had,
And get that.
Yeah, yeah.
Everyone, you got the review because it was previously submitted in the underlying.
For the repair, not the replacement. I saw all the stuff for replacement.
Right. Yeah.
But I didn't see any document, I didn't see any quote or documentation about repair of.
We submitted that. Because
It's been a long time.
Because they didn't ask us for it. All they did was they asked, well, did you did you have anyone come in to look at it to see how much it would cost or if it could be done?
Yeah, yeah.
And we said yes, and we gave them his name, Brian Kennedy,
Mhm.
and we told them what he had said and how much it was. Because all he did was send us an email and say, okay, I'm not gonna guarantee this because it's not gonna work.
and none of these
The
guys, like,
affidavit was submitted with this, correct? And it is referenced as part of in their decision, but the affidavit does reference the restoration or quote in 2021.
Yeah, it's quite a while.
Yeah, twenty.
So that's a smart legal document that has a bit more weight than like a random.
Yeah.
yeah, and that, now we had three experts look at this. Now the HPLC said, we don't like your experts. We're not gonna accept your experts. And what the judge said is like, you can't say that. The code doesn't allow you to pick your own experts. These experts are just as good as the city's experts.
And remind me, I saw one of the experts was on the New York Preservation, Commission. Yeah, or can you run us through who the experts were
There was three guys, who were the?
Jeff. Can't think of his last name. I can't think of what his last name. It was Country Home, right, Country Homes, Harvard, yeah, Jeff, I can't think of his last name.
Agent Farm contract.
Harley Davis, and then it was, Stephen,
If they never get a permit.
Stephen Cruz.
Have to reapply.
Okay.
Yeah, those three.
Okay. They didn't get
I
that.
can't think what.
Sorry, this is the one that was, Sarah McIver.
Oh, yeah,
That was someone the city.
yeah, the planning board director kept shoving her down my throat, to be perfectly honest about it. No one else, she never gave us anyone else, just her, and insisted that we use her, and then insisted that that's the person who had
Oh,
to
that
do the
was
work.
Emily Major.
And she agreed that,
Emily Major, I'm sorry.
okay,
MacGyver, she's from the state,
yeah.
yeah.
So Sarah McIver, Historic Preservation Technical Specialist with the New York State Historic Preservation Office,
Right.
reviewed your replacement, said that she found that met all over.
Yeah, that was the thing.
That's okay.
And here's, I do have, two of the originals, the H Country Homes and H from the Farms. You wanna look at those? And actually, I've got color copy.
Yeah.
Yeah, for this guy.
Oh, you're spoiling us now.
Yeah, you wanna, like, what, it's like, you guys wanna look at that too?
Already? Well, actually, I think if that's an apples to oranges, that kind of thing.
Each one of those gentlemen of the papers you're looking at there now have worked on historic houses for the last minimum of 20 years. Steve Cruz has done work in at least 15 houses between
Yeah.
Ulster County and Douglaston.
Is this where they just, these are ones where they just say that they. Yeah,
Didn't do your plus.
How long have you been partnering with daughters?
About 15 years now. So,
And is this the only house in the area that they?
oh, yeah, that's enough, yeah. Like I said, there's 50 women that
Yeah.
belong right now. It's just the one chapter right here. There's another one in Rhinebeck that has a house. There's one in Beacon that has a historic house. All over, Hudson is the one that's the public library.
And I guess the kind of headquarters or overseeing chapter helps in terms
Yeah, yeah.
of providing guidance
No.
just for the,
No,
how to preserve, or that's all done?
Windows
No.
would be kind of stage.
Okay.
it's very, it's more the exception that any chapter owns a house, period. Most people were meet in the churches or fire houses or whatever. We don't know. We're just the current stewards of this.
And it costs us money.
Probably they want. The old Windows fixed.
Well, that's what HLPC was asking for.
Well, we need to look at our minutes.
Okay.
So, guys, you, have a copy of the court's decision, right?
Yep.
I just wanted to see what, I can't remember exactly what the court said about that.
Yeah, I guess, there's a note here about the 2021 restoration quote, but like that document itself, I didn't see in any of the, I also very well might have missed it if it is there. See stuff. Because I'm curious to see what that actually says.
Referring to the affidavit they.
Well, yeah, that's the only, but that's the only place I see any mention of that.
Yeah.
Yeah.
And I thought the affidavit was one of the exhibits, or maybe that
and
in the application to you guys. Need to check that.
I did not see that.
I didn't see that.
Is an affidavit, exhibit. Davis affidavit. And in litigation.
Yeah, that's these ones.
Is that what they're referring to, that talk about the 2021 bill purchase? Or not, into the quote, the 2021? No, it's that. It's a different. You're referencing what is in the HLPC's decision.
Well, there's that, right? And then there's this, there's a mention of the Brian Kennedy, right?
So, Mr. Chairman,
Hair.
here's
Yeah.
here's what, well, here's really our position is,
Yeah.
even if it only costs $10,000 to repair all the windows, if they wanted to replace the windows, they would have the power to do that. And if there's no impact to the landmark district, the cost is really beside the point. The fact is that they determined that it was more cost effective to repair the windows, to replace the windows, especially because of the warranties and that sort of thing. But I just wanted to read what the court said. Now, this is what the court said. The HPL's determination to issue a preservation notice of action must be treated as its concession that the windows are in serious state of disrepair. If, as DAR attests, the building's original windows and hardware will replace circa 1910, it's difficult to discern a rational basis for concluding that the existing windows are historic or that replacing them with in-kind exact replicas would constitute a material change or result in the loss of historic materials. This is particularly so in light of the informal guidance contained in the preservation guidelines.
So what page of the,
That's from 10 to 11, where it starts with analysis. So, and then the court says, unfortunately, the court cannot reach the substantive issues, and it actually quotes the preservation guidelines for a designated landmark or building within a locally designated landmark district. Any exterior change to your building that is visible from the street needs to be reviewed. If you are simply, and this is in italics, if you are simply repairing or replacing something with the same material that is currently on your building or repainting in exactly the same color, no review is required. So you can see that was a reasonable approach that they took. They did their homework. They did their due diligence. They want to do everything right. They looked at the guidelines. They didn't make this up. These are the guidelines that the city had. So they thought they were doing the right thing. They got the windows. They were ready to go for the building permit at that point.
board thoughts? I'm inclined to, in case we want more information from the HLPC, to leave the hearing open while we deliberate. Is there any objection to that?
Well, you can close it for and leave it open for additional submissions, or you can also basically, these are already things that were submitted from the HLPC.
Yeah.
We can acquire those for you guys to review because they're all referenced in the documents as, for your determination.
Yeah.
So those are all other options that you have as well. If you do want to close the hearing.
Yeah. Closing the hearing 6 o'clock.
It does.
And then, and at least for now, there's no downside to deliberating while it's open.
Yeah, well, you don't deliberate until after.
Yeah,
But they do bring in more information and work out.
Does anyone on the board think they might want to see more information from the HLPC?
I'd like to know why they denied it. Yeah.
Well,
They simply denied the replacement because they wanted to fix the old one?
Yes.
I mean, they favor repairing the old one.
Which I will bring up too, they did contradict themselves in exhibit E. Page 10, they say the windows are in serious disrepair, but then also saying that they are restorable, so.
Anybody can restore anything, but the longevity of it.
But if they're saying it's in disrepair and then saying we'll repair it, I
Right,
mean, that's,
right.
we do it that.
Yeah, the reasoning.
Yeah, I saw that. And if they're from 1907, they're already over 100 years old.
Yeah.
I bought a camper 8 years ago and crushed it. Still using it. I got my money out of it. And well, that's what they- I think they got some money out of the old window.
Yeah, that's pretty good. Those last 120 years.
I don't even know that the new ones would last 120 years, you know what I mean? I don't-
You're not gonna get a warranty for that.
So do we need more information about that?
I necessarily don't.
I think they were of the thought that they had the authority to kind of force on an inn to replace them or restore them, and they did not want to hear that we were replacing them, and they were just flexing their muscle.
It does sound like that.
Yes.
Yeah, and from our perspective, I think you guys got all information you need for, I think the inquiry is the landmark criteria that you guys now it's your job to apply. And say, is there an impact on the historic district? That's basically, it's a pretty straightforward inquiry.
Part of the thing that we're gonna do that we don't, HLPC actually saw samples, like if we're gonna think about it from the point of view of the HLPC, right? We haven't actually seen the windows, they've seen the windows, it's hard, we can see.
Yeah, I hear what you're saying, but I also think that it's clear that they wouldn't have needed to see the windows. They took courses of action where they want to see it, but according to their own guidelines, no review.
Those guidelines are no longer the law and haven't been for a long time.
But weren't these actively listed on the website at the time that they brought
Yeah.
it?
That is a separate legal issue.
Got
It's
it.
not,
Well, we do.
what that says is not apply to us.
Well, we do have the court decision.
Yeah, but that's.
Sure, and if you want to fight that to the court, that's a
So when
different
you
thing.
can't take that, that doesn't necessarily mean that that criteria was determining what it is, but you can take that into consideration that they were relying on this that was on the website.
Understand.
Yeah.
They did look at the windows.
We brought one to one of the HLPC.
They thought they were.
And they looked at it quickly, I read that,
Yeah.
they looked at it quickly and walked away.
Yeah.
Yeah, because they didn't want to, they just didn't want to have to deal with it.
Both times we submitted the applications, there were also marking cut sheets for each and every window.
Yep.
Supplied at that time.
Yeah, I got those too.
Yeah, you could look at those, they tell you exactly what the windows look like.
Code today is unclear as to this, because that's what we're supposed to do.
Well, that's the thing, is like, if we can go through the criteria, for what the HLPC would look at, we can look at that and we can make your decision.
If we determine that this reads in the way that.
Yeah, so if you agree with the applicant that, based on, the way it reads under that subsection, and we do know what it read to before it was changed, now it is something that's completely not related to anything, has to do with enforcement. Then, yeah, if you interpret and say, oh, this is why it was written this way, this is what they mean by the landmark ordinance criteria, which is specific wording that they use in there, that you can apply that as opposed to the hardship criteria that is normally, which is what's referenced elsewhere in the statute.
I guess there is one other thing. At the point in time in which this application first went from the HLPC, what was the state of this language? Like, when this changed in the change in the code?
Which changes,
Well-
that the code's been, this section of the code's been changed multiple times.
Well, I think-
You have the original language.
I have the original here, yeah.
Yeah. And then there was the most recent, the language pertaining to certificates of appropriateness as opposed to notice, preservation notice of an issue. That was changed in November of this past year.
So that would have been after their original application.
At least after the denial.
Yeah.
Yeah, originally denial, I think.
Yeah. Yeah. I guess, like, if we are on the, if we are going to, if we're gonna do this.
So you were saying for the purpose of the statutory
There's-
construction.
Yeah, And if we're appealing, if we're looking at it from an appeal of the decision that the HLPC made entirely in their entire process about it, then don't we need to apply what was in force at the time of that application, or we do it based on what said next?
Well, the thing is, it procedurally came here as a result of, all right, and which application are we talking about? Because there was the most recent application that's all been subsequent to the change, right? When was the application, the most recent?
January?
September 2024.
That was when it was filed, right?
Yeah.
So that's after these.
So that's what the current, that's under the current.
Yes.
Yeah, current criteria.
So I would say then, based on that, everything is in trigger on that, because that's really what this appeal to the ZBA, their initial starting application, and then went through the hardship process, and now is that an appeal to the ZBA.
So, all right, so then the changes from the previous vote don't matter. We're looking at everything that's in the most recent version.
This was in effect from the day they filed their first, application, right? Of course, certificate of.
Yeah. And then we're saying that the only error in the way that the law is written is that number 14 should be a number 15.
Not necessarily. This is where the interpretation comes in. That was referring
If you
to
put that
14.
page over, there's no page.
We know that that is an error. The language there, and this is again up to you, the specific language is used in terms of applying landmark ordinance criteria as defined by, and we know that this subsection used to refer to the appeal section that says in disapproving or limiting preservation notice of action.
Okay. So the question is whether or not it's the section that it applies to, or is it the word applying landmark ordinance criteria?
Yeah, I would say, and this is the only field for a bigger moving.
Okay, all right, I see that.
So there's, it's up to you guys, you guys have the power to address it. Whereas subsection 15 refers strictly to a hardship decision, this subsection, which refers to applying landmark ordinance criteria as defined by the previous section.
Okay. That makes it a little bit more clear on what is actually in.
It's like based on that error, there's some contradiction within the statute itself. And
Well, there's still current, not only is there a typo of the number, but there's still current contradiction in the statute itself, because 15 doesn't mention that at all. Yeah, okay, all right.
Leave.
Should we deliberate about those two things separately, about the interpretation?
that's what I'm gonna get to, but I was thinking you want to turn the plan session and.
Yeah, that's right, we're at fine, yeah.
And then you guys can was agreed to.
Okay. All right, we are going to enter, what's that?
For the purposes of the hearing, are you going to close the public hearing? Are you? You can,
We're all confident that we don't need any more information other than from the attorneys. All right, so, I'll your motion to close the public hearing part of the appeal. There's a second. All right, we are going to take a few minutes to have a attorney-client session. If we'd all like to step out, you can stick around for the deliberations that we're going to go into after, but you don't have to. So,
All right, well, great, we've been at it this long. And we're hoping to get to the finish line. So we'll head out.
Thank you. Thank you. Amy, can you pause it again?
Do we need a motion to go into attorney client?
I guess, I've gotten mixed feedback on that, but it doesn't hurt to do it. Can I have a motion to go into attorney-client session? All right,
Who's doing that? Ian?
and
And
all right. I'm sorry, I'm like,
Give her 30 coming back.
have a pen for a second. So I guess we got two. Are they already clear on the two different issues that we have? Right?
Yes.
And I guess it took me a minute to recognize that there's the line that specifically says applying landmark ordinance criteria, right? That line exists in the current code and exists in the code that the previous version. And then section 15 specifically does not mention. And so that is the one thing, is that if we interpret the code that says that we can apply landmark ordinance criteria, not as defined by 4526 L15, because that's not there, then we can apply the landmark ordinance criteria, which is basically do everything that HLPC use their same process.
I'm sorry, can you just repeat? So you're saying section 14, you can apply the landmark.
Yeah, but this is,
criteria.
well, oh, wait, are we paused?
Think so.
No, we're live still.
Oh. I did it.
All right, I had
It
it
said-
bad for me for a while. All right.
Sorry, we're still streaming. So, pull that up.
Why do I know?
We haven't said anything bad yet.
No, but I'm saying why I can't get to the screen to let me,
recording it. It wasn't going to YouTube, but it's still, if you're in the meeting, you can still see it.
Zooming.
No, you have, unmuted, but you got it. Yeah, we're ready to resume.
Where I used to, we have lessons and microphones.
All right, everyone, thank you for your patience. We're back again. All right, so we are going to have a deliberation about our interpretation of. Right, the right page here, make sure that we are actually looking at the correct section. 405 L12(4), which the code says, in the event of the HLPC's denial based on hardship application, the applicant may appeal to the City of Kingston Zoning Board for review of said application, applying landmark ordinance criteria as defined by 40526L14. That's where the typo is. If it didn't need 15, there's no mention of the landmark ordinance criteria. So what do we think about it being, we interpret it based on 40526L15 versus we include the landmark ordinance criteria? I know that.
Well, referencing back to 12B4, it seems to me that anytime in here it's talking about the hardship application, right? It says that, but it doesn't mention hardship application, so that would mean we're applying that landmark ordinance criteria, and you're saying that would be 15 instead of 4.
Well, 15 specifically is only for the hardship, and the same landmark ordinance criteria is not included in there. So if we interpret the code to say that we can apply the landmark ordinance criteria, then that gives us a much broader interpretation of what we can do here. And
what they're referring to.
Yeah, of what the code is referring to. I tend to think that we kind of have to interpret it in the broadest definition. And if we want a more tight definition of that, that's going to require a move by the common council. I guess.
So just to clarify that it's your interpretation that is referring to what is now or was previously under that subsection, the criteria for preservation notice of action, but is now the criteria for a certificate of appropriateness?
Well, again, there's two parts of that, right? Because 15.
Yeah, no, so was when it was referred to preservation notices.
Yeah.
That's the current.
It's a current one. So, yeah. Yeah, I mean, so 14 in the current code doesn't apply to any of them, right? Yeah. So, but the 15, which was the old 14, specifically reserves the hardship. It doesn't say anything about
any criteria.
It doesn't say anything about the landmark ordinance criteria. But since in the hardship, which is which you were denied the hardship already, so you can appeal here, and what criteria we apply based on that appeal in this section, 4526L. I'm sorry, 4526L12B4 says applying landmark ordinance criteria. So if we interpret that broadly to mean that we can then apply that landmark ordinance criteria as a body here in the ZBA. All right, are we in agreement that that's our interpretation of that?
Yes.
Yeah, I agree, guys. Should we make a specific motion to
That would be part of the determinations, or whether you're discussing and you're saying that we are reviewing it the way we're looking to the state law and the way it was written, the intent that was there before, and the specific wording, not only the wording that was pointed out, where it's referenced in the other places differently for hardship applications, and here it's represented, reference for just the application, and it specifically says applying landmark ordinance
Yeah.
criteria. So you're,
So we'll do it
put that all in the decision.
decision.
But.
Right, I just want to make sure we weren't looking at
This
two
is
things
why,
separately. Yeah.
you don't need a separate motion to
Okay.
say, here's the one interpretation, and then here's our decision.
All right, so then looking at it from that point of view, we are looking then at the criteria for review, which is L10. Does everybody have a copy of this?
From,
Oh, and that's in Matt's memo, right? That's
If
in
you
Matt's memo.
have your specific, no, I don't think.
No, it's not.
No,
That's- you just had the hardship.
It's in the hardship application, 4526L10B.
Yeah.
Yeah, but do you guys have your actual statute, zoning statute, with you? That subsection L and 10, as
Just
the,
because of this version information, I'm
And I
gonna
can-
we're
I
all
can
looking at
read
the
it to
same
you.
stuff. Yeah. But this is the most recent one that we have here.
so do you want me to read the subsection?
I mean, I can read it. Should we read the entire thing or just the review criteria?
Just, where it says the application,
Like 10B? But 10B is their, review criteria.
statute.
I mean, I can.
Almost.
Following on.
Review criteria, making such determinations, the HLP shall consider. 1, the effect of the proposed work in changing, destroying, or affecting the exterior features of the landmark or landmark district on which such work is to be done. 2, the relationship between the results of such work and the exterior architectural features of other neighboring improvements. 3, the factors of aesthetic, historical, and architectural values and significance, architectural style, design, arrangement, texture, material, and color. 4, the special character and aesthetic interest that any structure involved adds to the area. And 5, the difficulty or impossibility of reproducing any feature or structure involved because of its design, texture, material, position, or detail. Right, so are you guys looking to go through the criteria and make a determination for that?
Yes.
I think we do that. Well, everybody reviewed this documents that were sent to the HLPC. Should have downloaded everything. I didn't download everything.
So with regard to the first criteria that you shall consider, the effect of the proposed work in changing, destroying, or affecting the exterior features of the landmark or landmark district upon where which the work is to be done.
Any thoughts?
Everything that's been presented shows that the impact has been intended to be minimal or non-existent.
I mean, I would generally tend to agree. Here's the window report.
is it this one?
Oh, that's the quote. Yeah. This is
Oh, that's the window.
I know this is fine. Like, this is the one that was like the most critical part and it still didn't, that seemed to be like well documented, you know, as far as I can tell, yeah, I'm sure someone with like the sharpest eye in the world might be able to tell the difference, but generally speaking, most people probably be able to tell the difference. Yeah.
Well, and I also think it's, you know, what's reasonable
Mhm.
going through multiple contractors, multiple experts and procuring from a company that apparently has reputable
Mhm.
replacements is about as much as one could expect
Yeah.
in terms of capacity.
Yeah, the one thing I didn't, did anybody else notice, there's like there was a few windows here that were like distinctly different and that, you had that, just had the printout of that, like, were those also the same, like,
Do you mean the narrow one?
yeah, there's a couple of narrow
I think
ones.
they planted to do it in the front door.
I'm
not sure.
No, this is like one on the second story, I'm just looking at that, yeah, which, I just wanted to know, like, those ones, but
Is that one you're talking about?
I guess it might be, I didn't,
Listed, it seemed like all the same materials as
Yeah.
the other windows. Same process.
yeah. Yeah, okay, yeah, I just, my only thought was like whether or not that double window was gonna turn into a single window, could it, and honestly could be more uniform, maybe it used to be a single, because all the rest of them seem to be, you know, like in that.
Oh, well,
You know, like this, see how like these are all one window, and that's like two, that's like mulled together,
Gotcha.
right, like, so. Which is
What
pretty.
was it, 200 years ago?
Good question. You know, like, so like this one is like two windows molded together. And like, so that was, but that does look like that's what that is, but. Yes, that's probably what that
They
is.
did say they measured each window.
Yeah. I'm
Also
going with
only
that.
two.
Yeah.
So, and if those are the two, then that would make
Yeah.
sense.
Yeah.
Oh, yeah.
That's the ones I saw were, yeah.
Yeah. All right, so, collectively,
So criteria one, do you mind rereading? Just
yes, criteria one is the effect. The effect of the proposed work in changing, destroying, or affecting the exterior features of the landmark or landmark district upon which such work is to be done.
Oh,
I don't feel it's gonna change that now.
Yeah.
It seems.
I will agree with that. So it looks like we've got that one. Relationship between the result of such work and the exterior architectural features of other neighboring improvements. Sorry.
and I also don't see how windows would affect.
Yeah.
Yeah.
Well, they would typically be on like the same building, but I don't think that, I don't think we have anything
No,
negative about that.
No, they're replacing the walls.
Yeah.
If anything, they would all look the same.
The factors of aesthetic, historical, and architectural values and significance. Architectural style, design, arrangement, texture, material, and color. I think the HLPC generally agreed that the colors and things that they were going after were the thing, am I wrong in that interpretation based on what you have there? Yeah.
No, I mean, I think this is kind of this gives the widest kind of interpretation of this one.
Yeah.
But it is interesting that there's nothing specifically about the aesthetic value that I've seen.
Yeah, I mean, I saw somewhere in the note that like they agreed that the color choice.
Yeah.
Right, do I remember seeing that? I didn't make notes about all that, but was appropriate. right? And we heard from the applicants that they specifically went for the certain version of the mat, because of its historical nature.
It does seem to be mostly the decision just on the basis that the existing windows are reparable, not. I don't see anything in these documents that points to a specific issue with the new ones.
Yeah.
They brought in the new ones back. It's,
I think they matched the color. Actually, she actually even quoted the color code.
Yeah. I heard that before, yeah.
Did her homework.
Do we have any other thoughts on that?
I mean, even to say the materials listed in here seem consistent with what would be available at the time, using pine for windows.
Yeah.
I would never do it, but you know.
Yeah. Although, that, 100+ years ago, that old growth pine was a whole different. It's not like southern yellow pine anymore, you know? Your glass would stay in for a week if you were using, like, that's gotta be, I can only imagine it's like kiln dried or something, or
Has
like,
to be.
yeah. Yeah.
I think similar to the first kind of qualifications, I just don't see anything in here.
Yeah.
Reasonably changes the character of the neighborhood or impact those items.
So we're in agreement that we, that we meet that criteria.
Yes.
Right. The special character and aesthetic interest that any structure involved adds to the area. It's definitely a special building in the area, although I don't know, based on our previous discussions, that this changes the character of it in any.
No, it just keeps it the same.
Yeah.
I do
Allows
think,
it to continue.
Yeah.
I do think that there's an irony of like epoxying something in and saying that means the character of the original.
They're like repairing rotted wood with modern epoxy.
Yeah.
Which that I haven't done before.
In desperate times. Yeah.
And then 5 is the difficulty or impossibility of reproducing any feature or structure involved because of its design, texture, material, position, or detail.
I don't think it's difficult or impossible if they already have one.
They say have.
Yeah. I mean, I generally would agree that to the best of their ability, it does seem like they have reproduced it in a as modern of a window as possible, but it does. It does.
And here's the design of
Yeah.
the original, so.
Yeah.
I wonder, can we interpret this kind of the other way as well, considering the difficulty of repairing the windows that are existing, right? I mean, there's it's kind of, they've gone on record with multiple people saying that it just seems to be a onerous responsibility to repair what they're currently is. So I can kind of apply both ways, I guess.
Well, I think it's intended to be implied that way, right? It's like, that, like, the default should be to like, fix the thing
That you have.
that you have, unless it is just not possible to make that anymore, right? And, so, like, but if the thing is, one of the word here is like reproducing any feature, right? So is it the exact same windows? No. Could you make the same exact windows? Yeah, it'd be very expensive and that's quoted it, but the feature of it seems to be largely the same, all right? And that, if we were to take a broad interpretation, I feel like that I could see someone being a stickler about that, but like, I don't know that we necessarily have to be, right?
I mean, it's, functionally identical, right?
And visually. So we're in agreement that this project meets that,
Yes.
Yes.
Yeah, there's 5.
yeah. Let's just double check. All applications shall be considered by the HLPC on at least one of the following points. These points to be used as a basis where relevant for establishing relationships to external features of buildings in the immediate neighborhood, building height relationship, we're not worrying about that. Size, proportionate spacing, openings in the facade, exposed to, these are all structural changes here. It does say in relationship to materials, textures, colors, relationship to architectural details, continuity of walls, relationship to landscape elements. The only thing here I think we're even talking about is the color, which we have already agreed that it's as close to historical match as possible, right? It shall further be the duty of HLPC to exercise judgment in accord with the basic decision stated herein and maintain the desirable character of the landmark or landmark district and prevent construction, reconstruction, alteration, or demolition out of harmony with existing buildings insofar as character, material, color, line, and detail are concerned, and thus to prevent the degeneration of property, to safeguard the public health, promote safety, and preserve the beauty of the character of the landmark or landmark district. Based on our previous discussion, I'm going to say that this action does not, agree in agreement.
Yes.
It shall further be the duty of HLPC to exercise judgment in accord with the guidance of the U.S. Secretary of the Interior Standards for Rehabilitation and or the Secretary of the Interior's other standards where deemed necessary by the HLPC. There were some mentions there, but we did, right, there was a thing from SHPO that I think maybe spoken did not say anything negative about this.
I think it actually
supported the change, that's why.
that was what you were looking at before.
Oh, correct.
Yeah.
Yeah, I think under analysis, they were.
Yeah, if you could find that, I'd like to say that.
Or no, leave it with the record.
It was Sarah McGuire.
Oh, because it's a scan, it's not, there's no text, yeah, I hate when that happens. You're like so used to.
What's up this thing? No pressure, I'm sorry.
Yeah, it's
This is my photographic memory with Rich.
As long as our iPad battery doesn't die right now. She's got some books like that.
Yeah. Enjoy some Reese's as I,
But I appreciate you, having done that and marked that up, because otherwise I would have.
Oh, this,
Yeah.
I can claim this. I think that might have been Amy that. Chill piece. Pictures.
Right, that,
SIPO,
okay. Which document?
It's number 21. She says, so historic preservation technical specialist with the New York State Historic Preservation Office reviewed our proposed window replacement, advised by email dated April 20th, 2022, that we had followed local requirements for replacing our windows and would certainly have met SHPO's requirements if we had saw their presentation.
I feel like that's enough to meet this
And it does
requirement.
reference an exhibit 8 if that ever becomes relevant.
Yeah, which,
Exhibit A, and it's number 21 on page 5.
okay. And that's of the That's the decision in order.
Affidavit document.
Oh, that's affidavit document,
Yeah.
okay. All right, so we, in our determination, we'll cite that.
Yeah, that's exhibit A,
Uh,
page 5, number 21.
Um. That is,
Yeah, there's no.
that's it, that's all we have to do, right? Yeah.
So you went through again, everything that was found, you read the others, D and E.
Yeah.
So now you evaluate the criteria, what's, their name development.
Yeah, it seems that we, have interpreted the code to say that we can evaluate this, as a ZBA, that we have the power to do that based on the way the code is written, and our deliberations seems to say that this is, an action that we should allow to happen. Are we in agreement? Yeah, all right, let's, all right, so Matt, you drafted,
Yeah,
ready to go.
let's, Amy has, we're gonna use the regular form. I took down notes from everything you guys were saying. If you want, I can essentially add in changes. And read through, and then basically you guys.
All right, because this is all hardship, so we don't need that.
We're going off the other criteria. There's the other one.
All right, so, so this is,
Amy, do you have?
Yeah.
Where is that one thing?
Yeah, the physical aspects, we could get their signatures.
All right, yeah, so this one does refer to, just.
It's a hardship.
Appeal of an application for certificate of appropriateness, so yeah, go with this one. But just,
You need to do a printout, is that?
okay, no, this is,
yeah.
I think this is, yeah. This
Yes,
is,
so you're granting that appeal for the following application.
well, I'm just gonna follow it. All right, so should we write this all out right now? Or,
Well, we can read it into the record.
Okay.
And then, really, yeah.
and then, yeah, all right.
All right.
Should I just say it as discussed, or do you actually want me to read these things through again and read it to record?
No, if you want, I can read into record, or you can just, go as discussed and just say what the determination is.
Yeah.
And then, you guys can sign the actual.
And we are granting an appeal. Right?
Yes.
Yeah. All right, so, we are looking at doing is granting an appeal to the for an application to the certificate of appropriateness, for, 116, 122 Green Street for installation of replacement windows, review of HLPC determination. We interpreted our zoning code to give us the authority to do that.
Interpret the zoning code to be referring to the landmark ordinance criteria of section
405-26 L 12.
Right.
No, well, first we interpreted the code on 405-26 L 12 B 4, where it states applying landmark ordinance criteria as defined, in the event of the HLPC's denial of a hardship application, applicant may appeal to the City of Kingston Zoning Board for review of said application, applying landmark ordinance criteria. So we interpreted that line as giving us the authority to reevaluate the HLPC's determination.
Interpret that as yes, referring to the certificate of.
Appropriateness, yes.
In section 405.26L10.
Yep. Which is review procedure for certificate of appropriateness. The board reviewed all of the criteria under that section as discussed. And it is the board's determination that this appeal should be granted.
I will take a motion to grant
your motion to grant this appeal.
I motion to grant the appeal.
All right.
I'll second it.
And all in favor?
I,
All right. We're good. Let's sign some stuff here. I will also.
Thank you, Mr. Chairman, and thank you, the
Oh,
board.
thank you. It's a little challenging to get through this, but you know.
Appreciate it.
I will accept hear a motion to dismiss.
to adjourn or
Adjourn. Get the hell out of here.
Motion to.
A motion to adjourn.
My motion is.
All right. Yes. Yeah, now you get to go back to them.
Wow, thanks, guys.
Yes,
Thank you.
thank you for giving us a wonderful visit.
Thank you.
Well, you know, we wouldn't have been able to if you didn't make a lot of business before that, so. Yeah.
Yeah,
Thank you, man.
appreciate
I
it.
think you still have to see that guy over there though.
Yes, are we back asking us? Can we come Monday?
There's a lot of people in the office now.
Thank you.
No, I know how much.
Like me.
Thanks a lot.
Oh, Colin is not.
Thank you very much. We'll be open for and close for 8 years. All of the burning.
Yeah, all different kinds of stuff.
Especially. Yes, that's full.
We get, we definitely will be ready for the questions. That's what we want. Thank you. Thank you so very much. You guys will have a good season. I'm sorry. You okay? Yeah.
That's still recording or just live?
This process. And we talked about it for a while today, and I thought I